All right, everyone. It's the court's understanding that in this case, a verdict has been reached. Are both parties prepared to receive the verdict?
Yes. You are.
Okay. So there's not to be any outbursts. Does everyone understand? Okay, we're ready.
All right, to the jury.
All right, everyone, please be seated. Ladies and gentlemen, it's the court's understanding that you've reached a verdict. Is that correct? And is that verdict unanimous? All right, Deputy, if you'll present the verdict form, please. Thank you. All right, the defendant will rise. The verdict form reads, we, the jury, find the defendant, Johnny Delarosa, guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment. You may be seated. Does anyone wish to have the jury polled? All right, ladies and gentlemen, I'm going to ask if this is your verdict. If this is your verdict, I need you to respond yes. Does everyone understand? All right, I'll start on the end. Is this your verdict? 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 All right, ladies and gentlemen, we're going to move to the second phase of the trial. But for that to happen, I'm going to have you all take a brief break because we need to set up a couple of things. All right? All right, everyone, please rise for the jurors. All right, everyone, you may be seated. And are you all going to be ready to proceed?
Think about.
All right. And they're going to take him to the back, but they'll bring him right back out.
Like 10 minutes.
Yes. Okay, no problem. Okay, and I'm going to print this. And Yaya? Yes. And I'll need mhm. All right, thank you. Attorney Martinez? All right. Can we line the jurors up?
Data witness.
Yes. All right, and on Meredith, is your client here?
Yes, they're both here. Did you want them to come in?
Wasn't there one of your cases that was dismissed or that was something else?
The other case is two clients that probably represent that we're gonna have a trial together, so they're both here. The Coopers.
All right, if you can have them come in. All right, on this case defense, if you'll confer with Rick Pena, of course, we're not going to be able to have your jury trial today, and this week is sort of a short week. So if you'll confer with him and Miss Ferguson on a jury trial date,
Okay.
and then that will be your date.
Okay, perfect, we'll do.
Can we just do it offline?
Oh, I mean, just have them call Rick down, and if you'll go in the back and speak with Miss Ferguson, because she needs to give them a reset form.
Okay,
Yes,
thank you, Jen.
you're welcome. All right. Let's bring them in.
All right.
All right. Everyone, please be seated. And state any opening statements.
We wait, Your Honor.
Defense. All right, state, call your witness.
Okay, called Officer Flesh.
All right, if you will raise your right hand, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so everyone can hear. And if you'll state your name for the record. All right, you may proceed.
Okay, Officer Flesh, I'm gonna ask you to speak up and speak into my so the jury can hear you, okay? All right, how are you currently employed?
San Antonio Police Department.
And are you a certified peace officer?
Yes,
How long have you been employed with the San Antonio Police Department?
just November 22nd, 6 years.
Okay, and what is your current title and assignment with the San Antonio Police Department?
Patrol officer.
And what are your duties as a patrol officer with the department?
Make routine calls, traffic stops.
Okay. Were you employed as a police officer with the San Antonio Police Department from February 15th of 2024?
Yes,
Okay, and were you a patrol officer on that date?
yes.
Okay. Do you recall what date or what side of town you were working?
So food area.
Okay. And what shift were you working on? Okay.
Usually,
How long did that run?
10 hours.
Okay, and what's the start and any time?
1700 to 03.
Is that like roughly 7 p.m. to 3 a.m.?
5 p.m. to 3 a.m.
Okay. And so on this date, were you dispatched to a purple can located at 4327 John Jackson Road, San Antonio, Texas, 78230?
Yes,
Okay. Do you recall why you were dispatched there?
I believe a disturbance time. Well,
Okay. And did you make contact with anyone when you arrived there?
the caller.
Okay. Did you generate a report at the time that you took this call?
Yes,
Okay. Would it help you to refresh your, well, do you recall the SAPD number associated with the call?
that's the PD.
Okay. Would it help refresh your memory if you have a copy of that?
Yes.
showing you what has been marked for identification purposes only as physically. Look at that for me. Do you recognize that document?
Yes.
Is that a fair and accurate copy of the report that you generated back on the date?
Yes.
So can you please tell the jury the SCP case number associated with that call?
That's APD 2403-5008.
Okay. And what was the name of the reporting party?
Audio.
Okay. And did she make a report involving an individual named Johnny?
Yes.
Okay. What was that report written about?
Sole contact.
We talked to it, Mr.
Judge, can I have a second?
Yes.
Did you do any follow-up on this, or did you refer to somebody else?
Reverted to offsite.
Okay, so all you did was show up at the scene, that was your entire involvement.
Yes, sir.
I have no other question.
No further questions, Your Honor.
All right, is this witness excused or subject to recall?
Excuse.
Oh, thank you. If you'll remove the microphone, please. All right, state, call your next witness.
Judge, at this time, we rest.
All right, defense
I'm sorry, what, Judge?
of the state rests.
Okay. Can I have a second?
Yes.
Yes, I call Patricia De Los Santos. You're good.
All right, thank you. Oh, there's a square microphone up there. Could you put that on your shirt somewhere? It's so that the court reporter can hear. If you can't put it on, if you'll just hold it. Yeah, if you'll just hold it, that'll be fine. Yes, thank you. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. If you'll state your name for the record and keep your voice up so that everyone can hear, please.
Patricia Grace Delarosa.
Ma'am, if you could move that microphone closer to your mouth, there you go. Now proceed, Judge.
Yes.
So, ma'am, tell the court how you related to Johnny Delarosa.
I'm his mother.
Okay, and you and I discussed what we're doing right now, right? Okay, and I guess the first question, to your knowledge, Johnny has no felony conditions, correct?
Correct.
And we've talked about his childhood. I guess, can you tell the jury what he was like as a child?
He was, who is he? He did, He did schoolwork like every other child. He was intelligent and he tried to get along with everyone.
Did he have any sort of, I guess, educational needs or emotional issues while he was in school?
I think he had attention deficit.
Okay. Anything else that you're aware of?
No.
Okay, and you understand that this phase of the trial is for the jury to make a determination about what to do with Johnny, right?
Yes,
Okay, so, are you asking the jury to consider granting Johnny, probation on this case?
yes,
Okay, and why is that?
because, you said probation?
Yes, ma'am.
Because I don't think he deserves to go, jail or prison because he too was attacked by that person.
And how do you know that?
Because I saw it
Okay, and when did that happen?
the day that it happened.
Or, yeah, the date or the time period? Was it prior to the date in question? The one, like, you know, when the case we just tried, right? You know when that happened?
April 9th.
Okay, and when you say he was stabbed by Nadia, was that prior to that April 9th date?
Judge, I'm gonna object as to lack of personal knowledge and self-serving
Did
hearsay.
you said
All right,
you
so let me
observed-
make a ruling. So that will be sustained. Defense, you'll need to lay the foundation.
You said you observed the incident, is that correct?
I saw it on a tape. I wasn't there.
And you weren't there, okay. Was Johnny, I guess, whether you saw it on tape or saw it in person, was Johnny treated for any stab wounds from that prior incident?
Yes, he was.
Okay, where was he treated?
Judge, I'm just gonna object as to, I don't think the foundation has been laid.
That'll be overruled. You can
Where
answer if
was
you know.
Johnny treated for these stab wounds?
At the University Hospital.
If Johnny is granted probation, will you continue to support him in complying with any terms or conditions he's given?
Yes, sir.
Does he live at home?
He's saying he right,
Okay. To your knowledge, is he employed?
not at the moment.
But I guess if given the opportunity of probation, you think he'll be able to find employment like he had before?
Yes,
Okay, I pass the witness.
Okay. Is it Miss Delarosa?
Yeah.
Okay, you are Johnny's mother, is that correct?
yes, ma'am.
Okay, and so on the night that this offense occurred, for the trial that we're here for today, you were at the Brighter Gate location, is that correct?
Yes,
Okay, and so, on that night, Johnny, your son, he showed up at that Briar Gate location, is that correct?
my mother and my sister live there, yes.
Okay, and so on that day, you had just gotten off of work and you were there with your mother and sister, is that correct?
I take care of my mother.
Okay, and so then Johnny shows up with a cutting wound, is that correct?
Stab, yeah.
Okay, and at that time, so the jury's seen a body worn camera, but at the time that the police arrived at the location, you were at the location with Johnny as well, correct?
Yes.
Okay. So I'm just gonna show you 3 photographs, if you can take a look at those for me, please. Okay, and so do you recognize the items that are contained within these photographs?
One of them's my car, one of them is me, and one of them is a pistol.
Okay, and do they appear to be fair and accurate depictions of,
I don't remember what the gun or pistol looks like, but yeah, that's my car and that's me.
okay. So Your Honor, I guess at this time we'll withdraw State's Exhibit P17, but offering P14 and
I have no objection.
All right, states P14 and P16 is admitted without objection.
Okay. And so the pistol that is in P17 that you stated you don't recognize, ultimately, when Johnny arrived at that Briargate location, he gave the firearm that he used to shoot Nadia to you. Isn't that correct?
I took it inside the house because I was supposed to be taken into the hospital. And, the EMS arrived and they took.
Okay. And then ultimately you did provide that firearm to the police. Is that correct?
And they asked me for it, yes.
Okay. And so how long does Johnny live with you? Is that what you stated?
He's living with me now, yes,
Okay. How long has he been living with you?
since he's been on, monitor,
Okay, and do you recall how long that's been?
not exactly.
But I guess as part of his bond conditions in this case, he's been on a GPS monitor, is that correct? Okay, and you have knowledge of that, correct? Okay, so at the time that he received the GPS monitor, are you stating that's the time that he moved in with you?
Yes,
Okay. And so are you aware that while he's been on monitor, he received a violation for being in unauthorized places he was not supposed to be at?
well, when I took him to the doctor, he was not even aware of that, so like, we stopped to get food,
Okay, so you're aware, do you recall what day that was?
you know.
Okay. So if there was a violation report that was submitted by his pretrial officer for stopping at 3 unauthorized locations, you're stating you're aware of that.
She mentioned it, yes, and then she told him, you know, he goes to the doctor, he has to come straight.
Okay. And so you were with him at the time that he was in these unauthorized places, is that correct?
I took him in my car because he was broke.
Okay. So if this jury decides to grant him community supervision, how are you going to ensure that he complies with the conditions that are imposed upon him?
Because he's going to be with me, living with me.
Okay, so where was he living at the time that he was showing up at Nadia's workplace and also hunting her down in the street? Was he living with you at that time or somewhere else?
He was working right there, at 7-Eleven right there. And she was always coming in, whatever, so he went, and then he moved in with me because he quit that job.
Okay. And ultimately, Johnny is your son and you love him a great deal, correct? Okay, and you don't want to see anything bad happen to him, correct?
Correct.
But do you believe that people need to be held accountable for the choices that they make?
It depends on what choice it is or what happened.
Okay. We pass the witness, Your Honor.
Defense.
Let me see the violation report. Ma'am, how long have I represented Johnny on this charge?
I'm not that sure.
Been over a year, right?
Yes,
Maybe 2 years? Close,
yes.
right? So the state's gonna bring me this violation report. And so you're aware there's usually restrictions on where people can go, right? And sometimes if people go particular places they're not supposed to go, the court can issue a warrant, take them back in custody, right? Okay. So let's talk about these unauthorized stops. May I approach the witness, Judge?
Yes.
Okay. So the state talked about these unauthorized stops. So when you say unauthorized stops, it sounds really bad, right? Okay, so don't read them out loud. Just read those to yourself, please. Okay, so you were driving Johnny around, right?
Yeah,
Okay, and why were you driving Johnny around?
because he was going to the doctor, plus, his car's broken.
Okay, So it looks like, did you read the first violation was you took him to where? Was that,
Walmart?
okay, and that was Walmart for an hour, right?
Yes.
You know what you got at Walmart? Okay, and where'd you go next?
H-E-B.
Okay, well, I know it was HEB Plus, right? That's a really big one, isn't it? So what'd you get at HEB Plus?
I think it was some type of.
Okay, and what date did this take place? Can you read that?
October 21st, 2025.
Okay, so that's his last month, right? Okay. And I'm looking at this, I don't see any other violations on here, right? And the incident we're talking about in trial took place in April of last year, right? Okay, where's the last place you took Johnny on October 21st of 2025? What is it? Can you read it?
Yeah. Whataburger.
Okay, where'd you get him? Okay, so the violations that the state is talking about, violating the bond conditions is Walmart, HEB Plus, and Waterburg, right?
Yes.
Okay. You weren't taking them to somebody's house or anything else like that. You took them to Walmart, HEB, and Waterburg, right? Okay. Now, obviously, the court can impose conditions. And that's something Johnny is gonna have to comply with. But I guess ultimately, like the state suggested, he's your son and you love him, you're just asking for the jury to consider giving him probation, correct?
Yes.
I pass.
No further questions, Your Honor.
All right, is this witness excused?
Yes.
Yes,
All right, if you will leave the microphone behind, please, and you may step down. Defense, call your next witness.
we call Nadia Newton.
All right, is she here?
Yes, yes, yes.
Maybe you'll take a seat here, please. All right, you're still under oath, and if you could restate your name for the record, please.
Nadia Newsom.
All right, you may proceed. Yes.
So Nadia, I wanna, I guess, talk to you about your history with Johnny Delarosa, okay? Okay? So an officer testified just before you about an incident in February of 2024 between you and Johnny at a convenience store here in San Antonio about Crew Road, correct? Do you recall that?
Not on Crew Road.
Okay, I'm sorry, I guess Circle K on Vance Jackson. Does that sound right? Is that correct?
Yes.
Now, did you and Johnny know each other from work together, or how did y'all know each other?
He worked at a gas station across from the Circle K. I don't know how he found out I worked at the Circle K, but he did.
Okay, so y'all, that's when y'all first came to know each other?
No, not really.
Okay.
I would buy from his store. I didn't want to get to know him.
Well, I guess, did y'all have interactions prior to that incident in February of 2024?
Other than him just following me out the store after I would buy my food or whatever it is I'm buying there.
this was also around the time he started getting more aggressive and following me with his car.
Well, let me ask you a question. So prior to this incident in February of 2024, was there an incident at the store where he worked, where you went in there and an altercation occurred and you stabbed Johnny?
At his store?
Yes.
No,
Would you stab him at another store?
I didn't stab him at the store.
Where did you stab him?
It was a separate incident when he drove up on me again at the same location he shot me at. And was taunting me and told him to leave again, and he wouldn't leave. And he kept grabbing me at this point, and gave him a fair warning that I feel threatened, and if you don't leave and stop grabbing me, I will defend myself. And he just kept apologizing and then walked up and grabbed me again.
Or did you report any of this incident to anybody?
I did report it to the police later, a few days later, when he approached me at my store.
When did you, so when was that?
A few days after he had tried to pull me out of the store I was working at.
Okay. Who, you reported that to SAPD?
I did.
Okay, and if there's no record of anything like that, does that mean it didn't occur or maybe you didn't report it?
I don't understand the question.
Well, I mean, if there's no record of this, of you reporting this stabbing, right? I mean, I'm just trying to figure out whether you actually reported it or not.
Like in the moments,
But you will agree, I mean, you stabbed Johnny before, right?
he stabbed him, I cut him. He
Okay.
was trying to grab me.
Okay, but you used a knife on him, correct, previously?
I did.
Okay. And you had previous incidents with Johnny, where I guess you were at the store where he worked, correct?
I don't know what incident this is.
Well, did you ever get kicked out of the store where he was working?
Yes, he was a manager at that store. I was trying to buy a soda and he told me that he wasn't going to serve me, that I asked him.
That, I guess, did that make you mad?
Irritated, but there's nothing I can do about that, so I left.
Okay.
And then he followed me out the store once more.
Yeah, I guess the question is, you said you worked at a convenience store across the street, right?
He did?
What was the need to cross the street to Johnny's convenience store if you were working in one?
I don't understand.
Well, you told us you were working in a convenience store across the street from where Johnny worked, right?
Yes,
Okay, so why would you need to cross the street to go to a convenience store where he worked if you were working in one yourself?
I wasn't working there at the time. This was before I started working there at the gas station.
Oh, okay, so,
And that gas station doesn't serve alcohol. They only serve certain items that I can't get from there, only similar.
okay, but then you got a job at the convenience store across the street from where Johnny worked, correct?
Yes,
In that, I guess, kind of unusual if you thought there was some sort of problem with Johnny that you would get a job across the street from him?
it was in my area, it was walking distance. And personally, I didn't see a reason why I should have to work outside of the area because of his actions.
Were there other stores in the area?
There was a shell, but they were overstaffed, so they didn't need anybody. Circle K, I knew 3 people that were working there, and it was very easy to get into Circle K because of that.
But I guess in your version of events, you weren't working at the Circle K prior to crossing to go to go to the store where Johnny was working, correct?
Correct.
Cassie,
Okay, Nadia. So if we're talking about prior reports that are documented involving the defendant, how many prior reports are there that are documented? Do you know?
I believe too.
Okay. And so that first incident where you called the SAPD on the defendant, that occurred in July of 2023, is that correct?
Yes.
Okay, and that was involving an incident that occurred at a Whataburger, correct?
Yes.
Okay, and so can you please explain to the jury what occurred in that incident?
My friends and I wanted to go get something to eat. Whataburger's walking distance from where we were living. And we just wanted to go get food and go to the Whataburger. And I guess he saw me across the street somehow. Because when we go inside the Whataburger to order food, he comes in with a Bluetooth speaker, blasting music. And then walks up to me and tries to speak to me. I didn't pay any money, honestly. I was very irritated with him as it was. And I just told him, you have no reason to speak to me at this point. Made it clear that you don't want to have a proper conversation about this. You won't tell me what you keep following me around. So it's just best if you leave me alone. The customer have to get involved and tell him to leave as well. I was there to buy food. He was just there to harass me.
Okay. And so then after that incident at Whataburger, did he follow you anywhere after that?
He did. I guess he didn't like the way the situation went down in the Waterburger, so as my friends and I were leaving, we get to the Mexican restaurant next door, heading home, and he pulls in and almost hits us, and then starts yelling at us about how that was embarrassing, how we embarrassed him, and that's not fair, and we all just told him, we don't get you, we don't understand why you keep doing this, it's ridiculous, we're too grown to be dealing with this. And I don't wanna deal with it. So just leave. And he didn't leave, he stayed, he kept trying to argue with us and even make, minor threats to us. And that's what really, made my friends upset. So they just kind of stood up for me.
Yeah, I'm gonna object the narrative response.
Sustain as to narrative.
Okay. And so I'm gonna show you what has been marked just for identification purposes as State's Exhibit P18. Can you take a look at that for me? And don't read from it, just take a look at that and then look at this right here and tell me if that's fair and accurate. Okay, and so this is an official police document documenting what you just testified to, correct?
Correct.
Okay. Now moving on, defense just asked you about an instance where you cut the defendant. Okay, do you recall that?
I do.
Okay, can you please explain or to the jury what happened in that instance?
I was with my friend and I was in a vulnerable state, honestly. I didn't have a good day and I was crying to him about something. And about 10 minutes into the conversation with him, I see John's car. He pulls into McDonald's, exits, and then pulls next to me, taunting me. And
Judge, I'm gonna object to narrative response.
Overruled.
Okay, so he started taunting you and then what happened after that?
I guess he had a few friends with him. He gets out of his car, he's still taunting me. I start screaming at him because I kind of lost like my cool. I was at my room and I had already dealt with something prior to that, regarding a different person, so I was just not in a good headspace. And to see his face after that just really upset me. And I even told him that, he caught me at a very bad moment. And I don't understand why you just keep harassing me, stalking me, and he goes on to start apologizing to me while also saying that he's doing nothing. When he's like, I don't know, it just confused me and also made me more upset. And he starts getting closer and I just said, back away, back up. And that's when I had, pulled my knife out, I said, back up. And he starts getting closer and starts grabbing me. And I said, I will, shank you right now. And he still went back away. So I cut his hand. And that's when he and I both separated. He's like, "Oh, you know, you just cut my hand." And I said, "I told you already. I told you to back up." At this point, I started screaming at him, said, "Just get in your car and leave." My friend was kind of watching the whole thing go down, and he started commenting and saying, "You put your hands on her, go away." And that's when I decided to just, you know, walk away too. Because he stopped at that point, he stopped following me. And I didn't want to, deal with it anymore. His friends had already left. They tried convincing me.
I'm gonna object again to narrative response.
Sustained.
Okay, and then so moving on from that instance, then we have the prior report that you made while you were employed at Circle K. Do you recall that?
I do,
Okay, and so you made that report on February 15th of 2024, is that correct?
yes,
Okay, and so when you called police on that day, they showed up to the location, isn't that correct?
yes.
Okay, and so can you explain to the jury what occurred on that day?
I was working my shift and, there's a couple of regulars that come in, so they came in and Johnny was in line with them. And at first I didn't recognize him because he had a beanie on and I didn't really see his face until he came up to the counter. He placed this bag on the counter and told me, "You know, you effed up, right?" And I immediately just told him to leave because I already knew that he wasn't here to buy anything. He was there for trouble. So I told him to leave and he wouldn't. He didn't leave. I didn't even want to know what was in the bag. I was kind of startled. I didn't know what could have brought that bag for and what was in it. So I walked away from the counter completely and stayed behind the yellow line and told him that he needs to go. And he said no, he gets in my face, starts getting aggressive. So I just walk out the store, both door telling me he needs to leave, and then he just starts grabbing me and pulling me out of the store. And I managed to break free. I had a witness there who was also telling him to leave. And she helped out as well, just getting him out of the store. And
Okay,
then I closed the door and tried to lock it, but he's holding the door open, trying to get it open. And I managed to, you know, pull it harder and lock it. And then I called the police.
okay. And then so when police or Officer Lesh arrived there at the Circle K, you in fact told him that Johnny had been harassing you for 6 months prior, correct?
Yes,
Okay, and you also told him that there was an incident a couple of weeks before him arriving at the Circle K that you were in, you felt that you were in fear and that you cut Johnny, correct?
yes.
Okay. Now talking about the incident that occurred at the Circle K, I'm gonna show you States Exhibits P15 and P17. So can you take a look at both of those for me? Okay, do you recognize States P15 and P17?
I do.
Okay, have you viewed the contents of both P15 and P17 prior to testifying today?
Yes,
Okay, and are they both video, like contain video evidence on them?
yes,
Okay, and you're depicted in both States Exhibits P15 and P17, isn't that correct?
yes,
Okay, and are they a fair and accurate depiction of the events as they occurred on the respective offense dates?
yes.
Your Honor, at this time, I'm tendering States Exhibits P15 and 17 to defense for inspection and offering.
I have no objections, Judge.
All right, P15 and 17 are admitted without objection.
Permission to publish. Your Honor.
Granted.
Okay, and so in states exhibit 15 that we're looking at currently, is that the video surveillance as contained within the Circle K?
Yes,
Okay, and is that you to the right that was just pointing at the screen?
yes.
And then regarding P17, I'm gonna ask you to take a look at it once it gets prompted up. If you're having trouble looking at the screen in front of you, just feel free to turn around, okay?
Just one minute tracking everyday trends.
Okay. So we heard an individual repeatedly saying, give me my phone, give me my phone. Who was the person that was saying that?
Johnny,
And is that the person that was recording that video?
yes.
Can you explain to the jury what you were doing when the person that was recording approached you?
I was walking towards the bus stop to meet up with him.
Okay. And who approached you at that moment?
John,
And what did he do to you?
he grabbed me and I tried getting him off me, but he had basically bear hugged me and we ended up on the floor where he started dragging me down the sidewalk and I kept someone to get off me.
Okay. And at any point, did you ever take his phone?
No, it fell.
Okay, and that's clearly depicted in the state's exhibit, correct?
Correct.
Okay. Did you want any of these interactions with the defendant?
No,
What type of effect has his continued harassment had on you?
um. I'm not sure.
Well, regarding his continued harassment, has that impacted like relationships and where you live or anything like that?
Yes, heavily.
How so?
I ended up losing my job because of what happened in the incident on the 15th. He followed me home, so I couldn't feel safe in my own apartment. I obviously couldn't shop at the same corner stores I usually shop at. And even then, I couldn't even walk to my own bus stop without him following me around. And especially after the shooting, I pretty much lost everything. My job, my home, and my financial stability, and my own mental stability as well. And all because I said no.
And when you say that you stated no, I guess, can you explain to the jury, like, do you recall the first interaction that you had with Johnny and what was that like?
I do. I went to the store, same gas station he was working at. I went to buy dog food. And I walk up to the cash register and the first thing he says is, I know you're over 18 and I know you're a woman, which threw me off completely. So from the first interaction, I was already not interested and also uncomfortable, but I was only there to get my items and leave. And even after just me wanting to get my items and leave, he didn't seem like he was going to just let that happen. And he followed me out the store the next few times occurred.
And is it fair to say that he kind of fixated on you ever since that first interaction?
Definitely.
Okay. And so ultimately, it's your testimony here today that his actions against you have cost you your mental, physical, and emotional stability. Is that correct?
Yes.
We pass the witness turn.
Defense.
Copy that.
Oh, I marked it.
All right, is this witness excused?
Yes,
Yeah.
Your Honor.
Yes, we approach.
Yes. All right, to the attorneys who are on Zoom. Yes.
But we are ready on here.
Okay.
We're ready on T Arena. That's the bond. Yeah, he's on.
You know, the page, 5 down the back. They're actually.
All right. Just one moment. Charles Atwell. Okay, all right, then Tiarina. If you'll have him come forward, please.
Good afternoon, Your Honor.
We have one. Well, 13.
All right. You all have a chance to review the forensic interview.
I've had a chance to review it, Judge, when we, let's see, Ricardo here. We had wanted to, but I want to review it with my client. And so there's a process where they do that. He was, I don't want to speak for him. He, I guess, wasn't, well versed on that process. I did speak with, the other felony prosecutor. She says there is a process where they'll have us review it in the jury room, or they'll bring it down and they need to have an investigator in the room and they have to be there.
Norma, recall this. This is your final plea deadline date. And Norma, if you'll recall it for December 9th.
Is that day work for you?
I'm gonna take the exhibits back.
Your Honor, is it possible to do that after the 12th? Because we were also, I'm assuming the court doesn't have time for it today. We also had our tracking motion that we had on file that we were gonna ask about, but I don't know if the court has. He hasn't had any issues. He's been in court, always on time, always.
Right, so what is the issue with the December 9th date?
My wife is gonna be out of town,
All right,
and she's going to New York, and she would like to visit.
so how's that gonna, I don't understand how that impacts your court date.
She would like to visit.
No, I mean, that date is your plea deadline. That's the date where you tell me whether or not you reached an agreement. And so it's gonna be set for December 9th.
Okay, but you're not saying that you wouldn't, are you gonna have transportation issues that day?
Yes,
Because she's your ride?
because
Yeah.
she's my right.
Well, I mean, isn't there via
Um,
Uber, Lyft?
is there a date sooner, Judge?
The 9th is fine, ma'am.
You sure? I
Yes.
mean, we can do it sooner.
No, you're good.
I can set it for
But if you're saying the 9th.
The 9th is fine.
December 1st, December 2nd.
The 9th is fine.
You sure?
Yes, ma'am.
All right, so
That was, yeah, that was.
it'll be December 9th.
Okay, we'll be trying to arrange, that. Thank you.
And then with regards to your motion, counsel, if you want, that can be done by Zoom. And you just let Ms. Ferguson know a date.
Yes, yes.
Who else is ready?
Homer's the lead, page 8, 4 down.
Homer Vasquez Solis.
Thank you.
You're welcome. Thank you for dressing appropriately for court.
You have a great day.
All right, you too. Hello.
Hi, how are you?
Hi.
No.
Okay.
Obviously, more bigger shit to do today. I'm gonna ask for this again, and I'll do the paperwork and just whatever day she gives me. I'll come in.
Okay, counsel, this is not a motion to revoke or
I'm
anything,
assuming the
correct?
break is not at all.
All right, so where are we on discovery?
I believe we have all the discovery. The one thing I know is outstanding is a BAC blood result from the same incident. There's also a DWI attached to this misdemeanor. And I haven't seen that pop up yet, but Megan was able to access it, so I assume it's in the pipe.
All right, and do you? The DWI, is that a felony DWI or misdemeanor?
Misdemeanor.
Okay, so that's for that.
Yeah.
So any?
Well, I think it's, I'm sorry to interrupt.
No,
but
no, go ahead.
I think it does inform the whole situation, how, if they intend to use that as evidence of this top security.
All right, so are these all alleged to have been on the same date?
That's correct.
All right. And state, when is the blood discovery on this case? Do you have an anticipated date? It's on Homer Vasquez. What is the offense date? Do you know? I know this was indicted in 2025, but I don't know the date.
The blood results are back. I'm
they're
not
back?
saying they're outstanding. I just didn't see them before today, before Megan was able.
Oh,
okay,
25
yes.
is a misdemeanor.
Sorry, I'm a little confused. I'm just gonna back up. So we made a plea offer today, I guess. Yeah, what are you asking more for more time?
No,
for
dude.
discovery?
No, the judge, I don't need to get all the blood discovery for this thing. The judge was just asking if there's any discovery outstanding, and I say, well, I haven't seen the blood result uploaded to e-discovery.
and see, I thought that meant that the blood discovery wasn't in, but it's in. He just hasn't seen it.
Yes, Judge. So I guess the plea would involve, or the offer that was made not to get into negotiations, but it would encompass some misdemeanors. That misdemeanor still needs to be officially filed in county court, so if we could just have a reset for him to do that discovery and for my office to get that case filed.
All right, Ms. Ferguson, I need a plea deadline date in 30 days.
It'll be, December 18th.
Can we do it just before that, because they're leaving on the 15th, so something, you're leaving on 15th, so something like the 13th, 14th, if that's not a weekend.
13th, 14th, the weekends. You can do it
Before that's fine, yeah.
before. Which ones?
And if this involves a plea in misdemeanor court, you can go to misdemeanor court first.
I can do the 11th,
That'll work.
it's a Thursday.
Thank you.
All right, once you sign the reset form, you're excused. Thank you for
Thank
your
you.
patience
Yes,
and
ma'am.
thank you for dressing appropriately for court. Who's next?
Jasmine Lynn. Page 6, 4 down.
Stand right there.
All right. So in this case, any outstanding discovery?
No, Judge, I believe discovery is complete and a plea offer was tendered today.
All right, Ms. Ferguson, put this on December 11th as well, and that'll be your plea deadline date. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court. You're welcome.
It's correct, though, just, you know.
All right, who else is next?
Have Sebastian Moreno, page 5.
And do you need to put something on the record?
Yes, with my client whenever the court's ready.
All right, whenever you all are ready.
Yeah.
Yes.
Page
And-
5, 4 down.
All right, Sebastian Moreno. Hello, good afternoon. So on this case, today we are set for disposition.
Yes, Judge, so last setting, counsel wasn't here to negotiate with me. We got it today, we negotiated, it took as bit. We finally have it,
Mhm.
but I know you have sentencing, I want to just recall it to give us time to get the paperwork done and then come in and then knock it out in front of you.
All right, we'll recall it for the 20th.
Your thing and number.
Thursday.
Thursday, Judge, that's the day, that's the day I'm cooking turkeys for my.
Oh,
can
that
we-
is
I
true.
don't know if you have anything next week. If not, can we do the December 2nd, that first week of December? Okay.
You said November 20th, Judge?
Yes, Thursday. All righty, and actually, defense, if you call a witness, will this be your last witness?
I think we resolved the issue. I
All
can
right.
put it on the record now. I think we'll rest.
All right, so, counsel, if you all get that done, we can get it done today.
Okay.
All right.
Okay.
Hold on. All right, if Yes.
Luis, it's Luis Morales.
All right, and defense, if you'll review the jury charge, please, for punishment. All right, and, oh, no, you can come forward. Who's next?
Luis Morales,
What
on page one.
If you're coming up first.
One at the bottom.
All right, Luis Morales.
So the state provided me the videos that I was missing.
Okay.
I just need a little bit of opportunity to go over those videos. One of them's an hour and a half and the other one's another hour.
Okay. And how much time are you asking for?
Maybe a couple weeks, Judge.
All right, and have you already received an offer?
Yes.
All right, Ms. Ferguson, I need 2 weeks reset for a plea deadline date. Yes,
I can do December 2nd.
Can you do the following day? Please.
Fourth.
Yeah.
Or the
Yes.
is it the 4th?
following date, the 3rd, and the Wednesday.
All right, so the 4th.
Okay.
Yes,
Thank you, Judge.
thank you. Thank you.
And that's the plea deadline?
Yes. And state and defense, once you reviewed the jury charge for punishment, let me know if there are any objections.
Yes, sir.
Anyone else who's ready?
Yes, there's the Luis Leon. That's Patrick Samuel.
Anyone here who's ready?
I'm
ready, Judge Kelly Green.
All right, who do you have?
I have 2 matters, Alonzo Winnington for a reset and David Gonzalez for a plea.
All right, Alonzo Winnington. And what page is Winnington on?
I have no idea.
All right, Mr. Winnington, why were you late for court?
Morning, take care of the dog.
I'm sorry, what?
My sister's dog, I was reading that, I'm not sure that the dog.
Okay, you keep trailing off and I don't hear what you're saying.
I had my sister's dog this morning, and to make sure that the dog was properly taken care of, I had to take some.
Understanding.
All right.
This is very.
All right, Deputy Laura. Winnington is on page 7.
Whittington?
Have you looked him up in the system?
Yes.
All right. All right. Ms. Green,
Yes,
your attorney, Mr. Winnington, for some reason, he is listed as a fugitive and he has a warrant.
okay. Is it
So-
a warrant for this particular case or another case? Because the state informed,
It's another case.
okay, that's what the state informed me this morning. All right, that was our reason for a reset.
All right.
And then
Ms.
I'm,
Just 1 second, Ms. Ferguson, recall this for December. All right,
You don't have an agreement to set a bond that's set on your docket today? The state is an agreement to 30,000?
you'll need to take that to Judge Nahara.
Yeah, well, you
All right, thank you. If you'll let Ms. Ferguson know.
okay.
and we're ready on a plea for David Gonzalez. He's incarcerated.
We're waiting on that. Yes.
This is an MTR where the defendant is remanded without bond. I have filed a motion to set reasonable bond. I believe the state will make a recommendation, which I think I can go with. But he is not here today, or he's in custody, but he's not here today. I know sometimes we like to inquire as to special
Yeah.
conditions and things like that.
Yes. If you'll speak with Ms. Ferguson, she can have him placed on the docket.
Okay,
Yes.
thank you.
You're welcome. And counsel, if you're not in court, you can appear by Zoom for that hearing.
Thank
All right, Ms. Green, your client has not been brought up yet,
All right,
so we're waiting for him to be brought up so that so that the clerk can swear him in. So just give me a
All right.
moment to put you in the waiting
All
room.
all right, very good. Thank you.
Brian Arnett.
Okay.
Yes, Judge, I apologize. Give me just about 5 minutes. I just picked something up that I gotta finish up and then I'll be right with you.
All right, I'm gonna have to put you in the waiting room.
No problem.
All right, Alfonso Cabanas, who are you here for?
Former labor judge, he's in custody.
Okay. Mr. Cabanas, if you can come up, please.
Yes, Judge.
What page is his client on?
Page 7, down.
All right, you're on Omar Leyva.
Yes, Your Honor.
What is happening with your case?
Judge, there, I think it was like a discovery status.
Mhm.
So I believe we have, or I have everything the state has in their possession. There was a plea offer made.
Okay.
And at this point, my client's gonna think about it.
Okay. All right, Ms. Ferguson, if you'll call this in 2 weeks for a plea deadline date.
That's fine, Judge.
I can do the 9th. For 9th.
Yes.
All right, we'll see you back on December 9th.
Thank you, Judge.
You're welcome.
Another one requesting the reset. And they're in jail as well. It's the Diana Valdez. She's on page 940. Wait.
I'll try to work it out. Okay.
All right, to the attorneys in the court, whatever you're doing, you have until 3:30 to accomplish that.
Mason, Judge, Bill, it's David Garcia, and Dr. Burns.
David Garcia on Eric Mason.
It's on page 4.
Yeah, what are you doing?
Good afternoon. Oh.
They can clean these.
All right, do you have all of the discovery?
I do, Judge, and we're still negotiating on an offer. I think there's still a little bit of investigation. We're asking if we can come back in 2 weeks.
A tentative offer was given to I just watched the video and I should be able to have it updated as to what option.
All right, you all need to confer off docket. Ms. Ferguson, set this for a plea deadline date for the last week in December, please.
December 15th.
December 16th. Thank you.
Thanks, Judge. And if we work something out sooner, we'll try to come sooner.
All right, thank you.
You said Judge, I was the pre-deadline.
Yes. Just a moment. And Kelly Green has someone, she says the paperwork is done.
They had to swear in the defendant, Judge.
He's not here, Judge. Cause I did not see her. I know. Get up.
Just give me a moment. I just have to put some things in Odyssey. Yes.
It's just, I see my client, Mr. Leal is still here. This is the motion that you sent down to Judge Nahara. It's already been signed. So I believe he can go back.
Yes, do we already have a date for him?
I believe so, yes.
All right, thank you. Yes, he can go back.
Thank you.
All right, who else?
I also have Martin Martinez, he's 5 down.
Martin Martinez.
Sorry.
That's okay. Come forward, counsel. Counsel. So today is your plea deadline date. All right.
Get him out.
Date on Martin Martinez.
Yes, Your Honor.
I need an acknowledgement of discovery done.
Okay.
And how long do y'all expect this jury trial to last?
What kind of case is it, Your Honor, sir?
It is an injury to child, elderly, disabled.
Oh, is it family violence?
Yes, well, no, I don't think
it's No?
No.
Okay, probably 3 days, Your Honor.
All right, Ms. Ferguson, I need a jury trial date, 3 days.
What's the case number, 20? I think it's January 20th. What's the case number, 20?
All right, defense, your jury trial date is January 20th. That's the earliest setting we have.
Wait, Judge, that's family violence. It is family violence.
Okay, sure.
Right here then, Judge.
All right, who else?
I have a Darian Fish, page 1, 5 down. It's a virtual. Cemetery County.
All right, all right, your client is not here.
I don't.
So could we make sure that he's appearing by Zoom? And if you could talk to whoever's in charge of Odyssey, that when they say there's a virtual booking, it needs to be on here because otherwise nobody knows where this person is and they're on the docket. The attorney's here, we're here, and we're expecting that he's in Bear County Jail and he's not.
Maybe if they could get.
Oh, usually they're in custody in another case. All right, I mean, another county, but they got their bond here. All right. I need a extension on his plea deadline date, and if you can have his client here, please, by Zoom or either in person. And set it in December. Yes,
Is that Mr.
Fish,
Okay. But I wasn't sure if it was is that for a plea deadline date?
yes.
'Cause I don't think we had an offer.
No, that's for the plea deadline date.
Okay,
All right, what date?
December 1st.
can we have the line?
Sure.
But David, just because that's the day we have for Mr. The other gentleman. Hearing.
Judge, do you have a defendant on here right now from the county? That's for the first.
No, I do not.
Honestly, that I have a concern still, it's had a lot of modifications to the indictment, would you like to go ahead and make those changes?
Yes.
beforehand?
Yes, thank you.
Yes, again.
May I first briefly?
Yes.
Do you like to?
This is he's in custody, Mr. Lozano, and he's separate today, but we're asking for the appointment of an investigator on his case. Some new stuff has come up. I don't think it should delay anything. But
I just
the witnesses that he's brought to our attention that we want to get in.
appreciate you sharing it. I try to be as transparent as I can. Yeah.
And who, well, he's in custody, but I'll just wait for you to call it.
Really, that's the only question I had, like, did he just pull a fast one on us?
No,
Or,
okay.
okay.
I mean. You did, that was.
All right, Alejandra Gonzalez.
Charles said something about.
Can I have somebody from the state, please? Court is calling 2024 CR 012194. State versus Alejandro Juarez Gonzalez for the state.
Melissa Albin for the state.
All right, this hearing was scheduled at 9 a.m. It is 3:09 p.m. The defendant has not made an appearance. State.
Your Honor, we'd ask for bond forfeiture and a judge's warrant.
All right, that'll be granted. He'll be remanded without bond.
What is that for?
That's Gonzalez on page 1. Alejandro.
Thank you.
You're welcome. All right.
The new cases? Yeah.
Miguel Contreras.
The labs might be
Excuse me, what
back.
is Miguel Contreras set for today?
Yeah, if you don't mind. It's 988. Sorry.
What is Miguel
11-3.
Contreras set for?
Yeah. Got some possession with intent, yeah.
Did I see that?
But they're set for grand jury on the 20th. Right, that's what I was gonna say. They're, yeah, I think, so. And it depends on how much drugs she got.
Luis Morales.
She's already on probation for drugs and now she, I don't know, is she dealing? We'll see.
Okay, let me check. What date was he given?
Number 4.
Okay, thank you. I see he has more than one case on the docket.
Yeah.
All right, on Mr. Vincent Savage. We are going to recall that for the first week in December and let them know at the jail he can appear by Zoom. And if he doesn't want to appear by Zoom, then he needs to be brought over. All right, what date, Ms. Ferguson? All right, thank you. David Gonzalez. Has David Gonzalez been sworn in?
No, I don't have the mouthpiece.
All right.
When did he come? I've been asking.
All right, Ms. Lefton, who was your client?
Hi, Judge. Oh, wait, is my camera right? Okay. I have Miguel Contreras. He's on the first page of the docket.
Okay.
And we would ask maybe that it be reset into December 12th. We just didn't have a chance to confer this morning.
All right.
Do we even have to swear on ourselves?
Maybe do a jail sanction. Probably, sounds like.
And your
Let me
client
check
is
the
not
fact
on
our
probation,
dealer
correct?
is Her boyfriend.
I don't think it's an MTR. I thought it was a new case, but I could be wrong.
Ms. Abrams, can
He
you
has
check
to
on that? It's Miguel Contreras. It's 2020
Welcome.
CR 012263.
You just have that case, she has no.
On probation, in that case,
Thank you, because that's what I have in my notes, that he's on probation.
Oh, I'm sorry. Then maybe if we could come in.
I don't have it listed as the MTR, but I do have a court summary that's been approved and we're ready to go.
All right, so he's in custody, so we're gonna
Yes.
call it, but he's on probation.
Okay, perfect. So when could I come on Thursday morning?
Yes, Norma,
Okay.
recall this for November 20th. All right, thank you.
Okay, see you Thursday. Thank you, Judge.
You're welcome. All right, who's here on Freddie Lozano? Mr. Freddie Lozano?
This is on. I mean, it's family violence, I don't see.
All right, today is plea deadline date. Did you receive the buccal swabs and everything?
No.
I didn't charge her with possession with indecent. Trying to figure out where they got the manufacturing and delivering.
Have you received the buccal swabs, the
No.
results?
I haven't received any new results, no change. Have there been any uploaded since our last one? Yeah,
Yes.
yes, sir.
That's okay. Ms. Ferguson, extend this plea deadline date for the last week in December, please. All right, and counsel, if you'll let him know if the buccal swabs are uploaded. And of
Yes.
course, counsel, if they're not uploaded, we'll
Yes, Your Honor.
change the plea deadline date.
I'll hang around today to see.
All right, thank you.
Yeah, that's it. Gonna get to see you.
All right, Joseph Daniel Dominguez. How are you doing?
Good, how you doing, Coach?
I'm doing okay. It's a long day. So your attorney was in jury trial, and I know your attorney came in earlier.
Yeah, he was just here earlier, I was looking for him, but guess he had to.
Okay. All right, this is what we're gonna do. On your case, we're gonna recall it.
Judge, he would zoom in.
All right, we're gonna recall this. And Norma, recall this for the second week in December, please.
Number 8.
All right, we're gonna call it in for December 8th. And that's to make sure that your attorney has all of the discovery, okay?
Okay,
All right, once you sign the reset form, you excuse.
thank you, Your Honor. You
You're
have a good
welcome.
day.
You too. Lindsay Turiano. That was already heard, correct?
Yes.
All right, thank you. Julian or Julian Tovar. All right, if you'll come forward, please.
Yeah, right, for that case.
All right.
Judge, I haven't sworn him in or anything yet, Judge.
All
I
right.
just got the paperwork right now.
All right. Do you have the paperwork for Gonzalez?
I do.
All right, is that ready? Thank you. David Gonzalez, if I could have Kelly Green, please.
I'm present, Judge.
Gonzalez?
Gonzalez, that.
Court is calling 2025 CR 0078892 State versus David Gonzalez. Could I have parties announced for the record for the state?
Megan Galloway for his state.
Defense?
Kelly Green for the defendant, David Gonzalez.
And are you Mr. Gonzalez?
Yes, ma'am.
Do you have any objections to your attorney appearing by Zoom?
No, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, did you review the true bill of indictment with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented? You're receiving on count 2, is that correct?
Yes.
All right, any objections to the waiver of count 1?
No.
Mr. Gonzalez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
And count 2, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial. You have a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed on count 2 at 350 days in the Bexar County Jail. There, under 1244, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Ma'am.
Oh, I'm so sorry. Let me redo that. Did you review the waiver of appeal paragraph with your attorney?
Yes, ma'am.
Did you understand it? Sign it in both places?
Yes, ma'am.
All right, by signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand that?
Yes, ma'am.
Counsel, are there any such motions?
No.
Then to count 2, how do you plead?
Guilty.
State any evidence. Any objection?
No objections, Your Honor.
Did you review the document entitled Waiver and Consent to Stipulations with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Sure.
Today, the state will be presenting evidence in the form of witnesses' statements and police reports. But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. How old are you?
18.
All right. So I know I've been moving very fast, but have you understood everything?
Yes, ma'am.
And do you understand that if I follow your plea bargain agreement, that will be a conviction
Yes, ma'am.
and it will be a felony conviction? Did you understand?
Yes, ma'am.
Do you need any more time to think about this before I review the stipulations?
No, ma'am.
Okay. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, just that you would follow the plea bargain.
All right. So, Mr. Gonzalez, who is Janelle Huerta to you?
Janelle Huerta?
Yes.
I don't know, ma'am.
All right. And how about Ariana Salas?
I don't know what that is either.
Maria Luna?
Maria Luna.
Mhm.
I was a sister of mine.
I'm sorry, what?
She's a sister to me.
But is she your biological sister, stepsister?
No, she's like a friend sister.
Okay. And who is Alicia Luna?
Alicia Luna.
Mhm.
I'm not sure, ma'am.
All right. And who is Gennaro Huerta?
That's the boyfriend of Maria Luna.
All right. So how far did you go in school?
Up to about 9th grade.
All right. So this is what the court is going to do. I'm going to find you guilty. I'm going to sentence you to 350 days in the Bexar County Jail under 1244. Give you credit for any time served. There's to be no contact with Janelle Nicole Huerta. Maria Luna. Alicia Paez Luna. Ariana Salas.
Let me just make sure.
Gennaro J. Huerta. And the court will give you, as previously stated, the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and did you sign it?
Yes, ma'am.
The blank sheet?
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
We can go off the record. So this is what I want to explain to you. You're young, you're 18, now you have a felony on your record. You
Your
understand?
Honor, may
Yes.
I interject?
Yes.
The defendant was just convicted of murder in juvenile court. He's getting ready to do 20 years on that charge.
Well, that
He
explains
also,
everything.
yeah, he has 2 aggravated robberies that are going to run concurrent 15 years apiece. So he's going to do some more time.
Here's the thing. Then let me just tell you this. Number one, this is a felony, right?
Yes, ma'am.
You have a murder, that's a felony. You have all of these other cases, that's a felony. Now, your attorney just told me what you received in another court as a juvenile on that. Here's the thing. You're gonna have to change your ways. You're 18. I know 20 years seems like a lot of time, but you committed a murder. You understand?
Yes,
If
ma'am.
you don't change your ways, your life is going to be spent in the prison. Do you understand?
Yes, ma'am.
While you're at the prison, you need to try to improve yourself. That means getting an education, getting your GED. You understand?
Yes, ma'am.
All right, good luck to you, okay?
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
Witnesses OD'd and died.
Anyone else ready with the plea?
Yes. I have already.
And he was gonna be CNT'd too. He was gonna be CNT'd on the murder. It's sent over as an adult.
And then,
Died. I mean, that's all. I don't know. Anything.
no.
Yes, I just need to click.
We're gonna take this one plea up. Tovar, is he in custody?
Yes, right there.
All right. Oh, they're not ready for you. So, and Bud Ridenour, who are you still here for? All right, thank you. And then on Sebastian Gabriel Marino. Come forward. And Deputy Laura and Norma. The other people who are in the box who have pleas, you can put them on Thursday and the attorneys can appear by Zoom for the plea if they completed their paperwork. And then we'll finish with the jury trial.
What is it all
So the-
up right now?
So the defendant will need to be here, Norma, but the defense attorney can appear by Zoom. Who are the other people?
Unless we go over the docket real quick.
Just give me a moment. The court is going to call Sebastian Gabriel Marino. Can I have the parties announced?
Megan Galloway for the state.
John Pettis for defense.
And are you Mr. Marino? Counsel, have you received all discovery? Did you review it with your client?
Yes.
Martin
The court will
Martinez.
find that the state is in compliance with discovery. Mr. Marino, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Marino, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with evading arrest detention with a vehicle that's a third-degree felony? Range of punishment is anywhere from anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
He was, Judge.
Mr. Marino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, yeah.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. The state recommends community supervision. There's no application for deferred adjudication. Taking in consideration 2024 PF 23175, 2024 PF 176. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes, Judge.
State?
Yes, Your Honor. I'm sorry.
That's okay. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution, the MRT, and aggressive driving. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offense as charged, how do you plead?
No conflict.
State any evidence.
State offers stage 1 in attachments.
No objection, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Is there any outstanding restitution?
Judge, we've not received documentation regarding that, so at this time, I believe we would waive.
All right. How old are you?
I'm 23.
All right, you're 23. Did you drive here today?
I got dropped off.
All right. So why are you doing this?
Well, to be completely honest with you,
Yes, please be completely
I
honest.
swear, I was going through the beginning of my divorce at the time. I had been with my ex-wife for about 6 years at that point.
Mhm.
It was just kind of one thing after another, and it escalated what it shouldn't have. And I've done a lot of different things now. Now I'm a volunteer firefighter. I do try to be there as much as possible.
So you say you're a volunteer firefighter. What is your employment status?
I work at a shop. I'm a technician.
You're doing what?
I work on vehicles.
Mechanic.
Yeah,
Do you have any children?
I do have a 2-year-old daughter.
All right, this is what the court is going to do. The court will sentence you to 8 years in the prison, suspended and probated for 6 years, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. Taking consideration 2024 PF 23175 and 23175, 23176. There's a $2,000 fine. Time with regards to a $2,000 fine, the court will probate that. Field visits 1 time per month for 6 months. Defensive driving course. There should be no driving for 6 months. MRT, 200 hours of community service restitution. Once 100 hours are completed, 200 hours of community service restitution. I'm going to require parenting classes. Once the parenting classes are completed, 100 hours will be deducted from community service restitution. The remaining 100 hours will be deducted upon completion of MRT. There should be a TAP evaluation out of custody, follow recommendations. And there is no restitution order. Probation, is there anything else that's required? No, Judge. Is there anything else you need from the court to be successful?
I know you said no driving for 6 months. That does tend to make it a little bit harder because I do try to get as much side work as I can just to help, keep up with my bills and everything.
Okay, let me ask you something. You were driving in recklessly, right? And then you were evading. And what happened when you were evading? I'm sorry?
There was a car accident.
Yes, and that other person, what happened to their vehicle?
I'm not sure.
Their vehicle was T-boned. So that probably means that their vehicle is not drivable. And you know how insurances are. Sometimes they'll give you a loaner, sometimes your insurance doesn't cover that because it's just liability. So this is the cost of your doing something that you should not have been doing, and you were old enough to know better. And if that person would have had a 2-year-old in the vehicle, who knows what would have happened? You understand? So this is a part of your punishment. You understand? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to the attorney. Do you understand?
Yes, sir.
All right, but what do you?
We keep it.
Yes, they'll go over conditions with you. Ms. Abrams, who do you say was still pending?
I don't know if Mr. Guerra is, Martin Guerra,
No.
He's in the 144 doing the sentence.
so I think there's like two clients for.
Yes.
I don't know who else.
Yes. All right, Deputy Laura. You can take them back.
Okay, they're not coming back.
No,
I
there,
think so. Is there somebody that?
is there someone who has a plea?
Yes, ma'am.
It's just an MTR judge.
And then I have a whole,
All right,
bargain.
do you have the paperwork on the MTR?
Yes, ma'am, I do. I have it right here.
I don't need a cat.
And then that other gentleman is right there in the morning.
Okay.
I wasn't considering you.
All right, the court is calling 2023 CR 3936, State of Texas versus Diana Valdez.
Melissa Albin.
From state. Lindsay Shaw for Ms. Valdez.
And are you Ms. Valdez?
Yes, ma'am.
Did you review the document as part of the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Diana Marie Valdez who was placed on deferred adjudication in 2023 CR 3936 for the offense of possession of controlled substance penalty for 1 gram to 4 grams on October 15, 2024 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
You can see it on number 2, Your Honor, on or about the first day of August 2025 in Bear County, Texas, defendant Diana Marie Valdez did then and there illegally use a controlled substance, namely amphetamine, in violation.
How do you plead to that? True or not true?
Oh, wait.
All right, did you understand by pleading true to violation of condition of the court to find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor, we're in agreement to extend her community supervision for a year and amend her conditions for status followed by aftercare.
All right, and what is happening to the other?
We're gonna take those into consideration.
And are you willing to do Senate and aftercare?
Yes, ma'am.
Probation is with the recommendation.
That is the recommendation, Judge.
All right, the court will deny the motion, alternate amend conditions to include an extension for 1 year. And SATA. Is there anything else you need from the court to be successful?
No.
All right, do you have any children?
Yes, ma'am.
What are their ages?
21, 19, and 15.
21, 19, and 15. And who are they?
My daughter, my 19-year-old watching my 13-year-old.
All right, and there's to be no unsupervised contact with minor. The court will reconsider once you completed the SATA.
Okay.
And I'm gonna order parenting classes. All right, good luck to you.
Thank you, Judge.
You're welcome.
Yep.
All right. Definitely. You can exchange it now.
I can't think, Judge. Mr. Whittington had a lot of stuff.
Okay. All right, as soon as we can bring your guy up, we'll take him up.
After wait this person.
Julian Tovar.
Lindsay. Lindsay, do you want copies of the dismissals or no?
I'll get them tomorrow.
Okay. Okay. Mhm.
All right, the court is calling 2025 CR 010147 State versus Julian Tovar. Could our parties announce for the record?
Ashley Jones for the state.
David A. Garcia, attorney for the defendant.
And are you Mr. Tovar?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
I have, and we have, Judge.
Court will find that the state is in compliance with discovery. Mr. Tovar, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
And it's the court's understanding you all are proceeding on a lesser included?
Yes, Your Honor, we are proceeding on the lesser included offense of indecency with child by exposure.
Any objections?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, the state is proceeding on the lesser included offense of indecency with a child by exposure. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine. Do you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you may withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will follow the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, and he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Tovar, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, Your Honor.
Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of indecency with child exposure, $1,500 fine, affirmative finding of family violence. There should be Chapter 62 registration, no contact with the complainant. Did you understand that?
Yes, Your Honor.
Defense?
Yes, that is the agreement, Judge.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
Filed but not ruled upon, Judge.
Outside the agreement, the state is recommending 7 years deferred adjudication and of course the sex offender unit. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, how do you plead?
No contest.
State?
We would offer states exhibit 1 and all offense, Your Honor.
We've reviewed states one and all attachments, Your Honor. We have no objections.
Did you review the waiver and consent to stipulation with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. So why am I following this agreement?
Your Honor, we have spoken with the family and the complaint regarding this plea agreement. This is how they would like to proceed. We believe is it, I know the defense counsel is in agreement with this plea.
This was something we worked out. It was long and hard worked out.
All right, and I do know the age difference. There's not a great age difference. And I say that and mean that according to this, he was 17.
Yes, Your Honor.
And then the complainant, I believe, was 13 or 14.
13.
Yeah, 13, obviously. Okay.
Yeah, pretty close to the
Cut off.
cutoff.
All right. Are you employed?
No, Your Honor.
All right, how far did you go in school?
Up to junior year.
All right, so do you live with anyone?
Yes, I'm wrong.
This is what the court is gonna do. Court will sentence you to $1,500 fine. That will be probated. The court will sentence you to 5 years deferred education. There's an affirmative finding of family violence. You're gonna have to register as a sex offender. There's to be no contact with the complainant. Proof of employment or full-time enrollment in school within 45 days. There's to be no employment as a home health care provider or with minors. Sex offender unit for supervision. Regular reporting by Zoom or in person. Regular random UAs. TAP evaluation out of custody. Follow results.
You understand what she did? It's 5 years deferred.
Yes.
All right, probation, is there anything else he needs?
Yep. 45 days to either get a job.
All right, is there anything else that you need from the court to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you
Your Honor.
understand it and sign it?
Yes.
Because it's a plea bargaining agreement, because I followed your plea bargaining agreement, because you waived your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, Your Honor.
Make sure you follow through on everything, and I hope you've learned something from this, right?
Yes.
All right, good luck to you, okay?
Thank you, Judge.
Thank you, Your Honor.
And Judge, on behalf of
Thank you.
my client and his family who are present, we thank you for this. Also the state for being understanding.
Thank you.
Good luck. Almost forgot to invite again.
And
Y'all have a good day.
thank you. And for pending, if you have a chance to review the punishment application.
Sure, we're okay with it.
Clarence Lacey.
Clarence Lacey?
Yes, ma'am.
What page is he on, guys? Do you see?
Looking right
All right. I'm sorry, number one, your attorney's not present. So what I'm gonna do is I'm gonna recall you. Have you had contact with your attorney?
Never.
Do you wanna continue with this attorney or would you like another attorney appointed?
Stick with the attorney. I just end up, no, I'll just get another, give
No,
it
no,
another.
I normally don't do that, but when people tell me that they have not had contact with their attorney, I'm inclined to give them another attorney.
Well, let's get another attorney, yes.
All right. All right, everyone, please be seated. The state you've rested, is that correct? And I believe the defense had started with their first witness and you are calling another witness, is that
Yes.
correct?
Defense calls Johnny Delarosa.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure that you keep your voice up so everyone can hear. And if you'll state your name for the record.
Johnny Anthony Delarosa.
All right, defense, you may proceed.
So, Johnny, you understand, what we're doing right now, correct?
Yes, I do.
Okay, all right, so you've been convicted of, the offensive aggravated assault with a deadly weapon. What do you want to tell the jury?
There's anything I can say?
Speak into the microphone, please.
Specifically,
Yes.
there were a lot of things that were shown about me that you saw, and there was a lot of factors there. There was a lot of also a great deal of things that y'all were not allowed to be privy to. Unfortunately, some witnesses I was able to bring that could come, would come. Fortunately, you were privy to testimony handpicked by the prosecution to hear about me. You were all allowed to listen to things and hear things that were custom made and tailored to make sure that you all.
And I'm gonna object to this line of testimony. There are legal rules, and I'm sure the defendant is not aware of them, but they have to be followed. And so I'm gonna object, that's completely.
Sustained.
So, is there anything you want to tell the jury specifically about why you think, you should be given a chance at probation?
Mine, I was just given, I can stay with the parameters I was supposed to stay within. I could sit here and say it was not this or not that. I could try to do all that with you, and I'm not going to do that. You all presented something, you all seen something, you all shown something, you made a decision on that. The only thing that I can say is things were not presented to you. However, you've made a decision on things that were presented. The only thing I can say is to throw away my life or to be, I've been convicted. And I want to have to live with that for the rest of my life, regardless of the decisions that brought me here, regardless of the decisions I made, regardless of the decisions that the other individual made. Well, I'm sure you were made aware of. My attorney said before too, it's a stupid decision, stupid argument. I gotta be here. But just for a stupid decision, a stupid argument, I'm here. I don't have to pay for that. But I will say this, at no point in this entirety of this entire thing did I ever cut tail, did I ever run, did I ever not cooperate with law enforcement, did I ever not answer any question, did I ever compromise myself. I answered everything truthfully, I said everything as the belief that I thought. The person, I was made the defendant, that person was made victim. At the beginning, yes, it was the other way around. Decisions were made, she was the defendant, and I was the victim. The way the law enforcement looked at it, you were there. Originally, she was in the wrong, and now I'm in the wrong. I'm not putting blame on no one because I can't. Who's to say why I was here? Who's to say? I heard so many variables, variations of the reasons of what happened. Thank God. And you know what? Even if it is God, I like to think that this is His plan either way. And I told myself before anything because I can't, and I'm not trying to. I'm just trying to simply make
That y'all hear me, because you were told so many things about me and you never were. You didn't, I never even said hello to any of you a day in my life. You never met me a day in my life, never known me a day in my life. I wasn't allowed to talk to you, but I'm pretty sure one or two of you might have saw me in church. I'm not trying to sway nothing, I'm not trying to say anything, I'm just trying to say that that woman in the back over there, she raised me a certain way. And today I told her that no matter what happened, you did a good job. You introduced me to God. You did the wrong, you did everything. I can't sit here and tell you that every decision I made was something where the outcome would have been where this is, because that is not true. What I will say is we are here. And what did happen led to this. And I am here. I was advised so many ways, and I took all that advice. I don't know how they say the Lord says, be still, be silent, and I was. I felt that with my whole heart, my whole soul, everything that was in me. This is my life, my life. And I'm grateful that my attorney advised against this completely.
And I'm just gonna object to your last narrative, not to violating attorney-client privilege at this point.
Sustain.
Okay. Well, Judge, I think the privilege would be mine, but nevertheless. So Johnny, I guess, are you asking the jury to give you a chance at probation?
To be honest, that's not even gonna be here. I just wanted y'all to hear. I just wanted y'all to know that I'm not. There were circumstances that made this was a mistake. A lot of the things y'all heard, and
Okay,
I'm
hold on. The judge has already talked about narrative. I'm gonna pass the witness. The state is gonna ask some questions for you, Johnny.
yes.
Okay, Mr. Delarosa, so when you were talking with Mr. Mauer, you stated that the evidence that was presented was handpicked by the prosecution, is that what you said?
That is correct, what I said.
Okay, and so you saw all of the exhibits that were presented to the jury, correct?
Correct.
And so the video that was shown in State's Exhibit number 5, which was your cell phone video, I mean, that evidence came directly from your cell phone, isn't that correct?
Correct. And to answer that question for you, oddly enough, yes, that came from my cell phone, which was taken the day it was taken. The detective that you had here refused to take that video into evidence. Refused.
Okay.
My mother
No.
over there,
I
we were in
want-
conversation,
You need to
and that
stop,
man,
stop talking. This is, I asked a question,
And
and you answer, okay? So you stated that the detective refused to take the video.
yes,
Okay, so please explain to me how the detective was able to watch that video and analyze it to determine to drop charges against Nadia. You heard him testify to that, right?
yes, and unfortunately for you, I had conversations with that detective, 2 of them. And I went over there to the public safety headquarters numerous occasions to give him that info, to see if he used that info. Not only that, I saw 2 videos that you showed. Actually, one video that you showed was actually 2 videos that you showed earlier. One of her coming up with the in front of the shell, I believe it was. Yeah. There's 2 videos of that. You only showed 1 video. You showed the second half of that incident. That was an incident that happened where all day she was stalking me with that camera, which my attorney has that video and you have that video. You showed, nah, yes you do. Yes you do. You're not lying about that.
Stop
You don't have
talking.
that.
I'm gonna object to argument.
Stop talking.
All right. So, that objection will be sustained. Questions will be asked. Just answer the question. All right, you may continue.
And so you are aware that the evidence that was presented to you, which your attorney had, there was only 2 videos that the detective was able to recover from your phone and turn over to the state. You're aware of that, correct?
I'm aware of the facts that I just stated to you.
Okay, and the truth of the matter is that these prior interactions that you're stating occurred that the jury didn't hear about, none of that was reported to the police, isn't that correct?
That is incorrect.
You never made, and there is no documented proof of you contacting 911, reporting any prior incidents, correct?
Incorrect. When I was working at 7-Eleven, There was many instances, of not only her and her friend, which I could have gotten witnesses in here again. And this would have been really helping me out with your prosecution exactly cut all the factual evidence that passed out, which you heavily did also have show them the heavily edited version of that video right here. Now, I understand the court's parameters of keeping things out of this situation, but if you're going to pick the man on the totality of an entire situation, at least have the decency to show the totality of the entire video, man.
So you're aware that there were legal rules, correct?
I'm aware of that.
Okay, and they have to be followed, isn't that correct?
I'm aware of that as well. That is correct.
But let's talk about what the full video showed then, since you wanted to get into it, okay? The full video shows you continually advancing at Nadia, isn't that correct? It shows Nadia saying, "You've already hurt me before, you keep touching me and you won't stop." That's what's shown in the video, correct?
Incorrect.
What is shown then?
What is shown in the video, as you see, is me recording her as soon as she comes towards me. Now, when she's coming towards me, yes, it starts there. They also started when I'm showing the recording. When I started recording, she was already coming back. That's the only reason I got out of my car. When I saw her get her knife and started recording. And that is not the first incident of her stabbing me. That was the second.
And the
Which
jury
legal
has heard that, okay? But the part that you're talking about that were edited out were
Yeah,
not,
Georgia,
they
yes.
were not admissible and guilt innocent because they were bad acts on your part. You understand that, right?
The bad act on my part of when she was intoxicated, and me, and I'm telling her in the video, which she redacted, and I'm telling her, you were drunk. No, I'm sorry. I told her what she did. She spit on me.
Okay, well, let's get into that. Because what you say on the video is that, and she testified that, you heard her testimony, correct?
She did not
Yes, she did. What
indicate
she
any of
stated.
it. She did not indicate any
Listen
of
to
her
the question. Listen to the question. What she stated was that she was in fear and she cut you, correct? And you referred to that on the cell phone video, yes or no?
What she
Yes
said
or no?
was to you and
Yes
the entire
or
group.
no?
No. She said she cut me in the hand, ma'am.
Okay.
She said she cut me in the hands. She did not cut me in the hands. Now, do you want to go and read the
Where did she cut you? Where did she cut you?
She stabbed me in the leg when I was helping her up when she was drunk, falling all over.
Just like you were helping her when
And
you
she
pushed her in the
did
middle.
when I said that I apologized to her.
Just like you were helping her when you pushed her in the middle against Jackson.
She was never pushed in the street. If you go back and see that video, she was on the sidewalk the entire time.
Okay, well, the jury has seen the video and they have rendered a verdict, which means that they disbelieve your theory of the case. But let's get back to exhibit number 5, okay? Because when you're speaking about Nadia spit all over you and this heavily redacted exhibit number 5, it's redacted because you tell her that she spit all over your cock. Isn't that what she said?
Is that what she did?
You're the one that said it. Is that what she did?
I said it because that's what she did. And I still have the pants at home of all the blood when she stabbed me and all of her, which was covered in alcohol.
Well, isn't it true that you stated that because that's what you wanted her to do, but she didn't want to, isn't that correct?
Absolutely not.
Are you saying
I also have,
are you saying absolutely not out of self-respect? Is that what you're doing?
I'm saying absolutely not. Fact.
Okay. Now, let's talk about these witnesses that you are saying that you could have provided to the jury that are not here. Is one of them Dan?
Daniel,
Yeah.
that man was actually almost a former owner who actually owed me and another witness that I had $1,500 apiece. And that deal was actually taken away from him for doing crooked practices.
Okay, well, so Dan was the owner / manager of the department. Can you please stop interrupting me? Listen to the question that I'm asking you and answer it. Is it that hard?
It's not hard to tell the truth, man.
Okay, then stop interrupting me. Dan was the owner of the 7-Eleven, isn't that correct?
He was partial on it.
And he acted as a manager as well at 7-Eleven, correct?
Supervisor.
Okay, and in fact, he was your supervisor, correct?
Actually, I was the supervisor.
Okay, well, you recall when you were at University Hospital,
General manager, sorry.
So he was the general manager. Okay. In his role as general manager at the 7-Eleven, did he supervise you at some point?
He managed the entire store. I was supervising, manager, John was manager.
Okay. And you stated to Detective Martinez that Dan, you lost your job at 7-Eleven, correct?
Incorrect. I quit that job because
Okay.
of Nadia Nicole Newton constantly harassing me.
Oh, okay. And so it was, what you told Detective Martinez at the time is that Dan took Nadia's side in this whole endeavor, isn't that correct?
That is incorrect. What I told him is that she went over there. I don't know what she told him. It was released personal information to her. That was not it. He released information to her that he had no right to. Information that he got from my employee application. And yeah, she stated in the same that she stabbed me. But she told me that it's too late. Dan already told me everything. He told me everything about you. That was the same night she kicked my the hood of my car in, actually, too.
Okay. So if I'm understanding this correctly, you're saying that Nadia complained on you to Dan, is that correct?
Incorrect. She was thrown out of the store for stealing.
Did she make complaints about you to Dan? Because that's what you told Detective Martinez.
To my knowledge, she went over there and got information out of it. That's what he told me.
And you're saying, okay, you know what? Judge, permission to approach the witness.
Granted.
Okay, I'm gonna show you what has been marked as exhibit 23.
All right, in defense, do you need to approach? My allergies are killing me.
And he gave her personal information.
Okay. I'm not done playing this. Go ahead and put this back on. Unless it's your spending.
Exactly what I told you.
Okay, go ahead and remove that. So isn't it true in that video that you state that Dan is the owner of the store?
That's exactly what I told you.
That's not what
Oh,
you
I
stated.
put them at that one.
Because I want to object to relevance.
Thank you.
All right, that'll be overruled.
Okay, isn't it true that you stated that Nadia complained on you to Dan?
She complained after I left the job. She was still asking numerous employees there over and over about if I was still there or not.
Okay, and you stated that you believe afterward Dan was disgruntled and helped Nadia by giving her Orpheus personal information. Is that correct?
That's what she told me.
So go ahead and put the headphones back on. Okay, go ahead and remove that. So you stated in the video to Detective Martinez that you stopped to just tell Nadia. What did you stop to tell her? Okay,
And so you are wanting her to leave you alone when we've seen the state's exhibit and it's you advancing towards her and you pulling up on her. Isn't that correct?
Are they asking questions? I'm picking up my mother from work. I had no intention of pulling up on anyone that day. It was an event where I saw her, and that was a few weeks after she had stabbed me. Making numerous of false reports. False reports are actually coming back to haunt me now. About things and events that never even happened nor occurred. About things and events that I could easily disprove to you. Yet, you took it upon yourself to not only redact so much information, yet you're coming at me with information now, which was redacted from the jury.
Okay. And you agree with me that you're the one that brought all this stuff, correct?
I would agree that you redacted a whole lot of things on this. That's what I would.
Okay, well, that's what we're talking about now. But let's talk about this. So it's your testimony that you were on your way to pick up your mom from work, okay? Yes or no? Okay, so it's my understanding that your mom was at work, right? And then she went to your grandmother.
My mother's a home health care provider. My grandmother is a healthcare patient.
Okay,
And the only reason I was even in the area is my relatives have been there for decades. Not only that, I work in the area. I've been in the area longer than that person ever was. That person only lived in the area from what I was told, maybe the moment that they met, and that was it.
so your mom is working at the Briar Gate location with your grandmother.
Yeah.
And so you're on your way to that location on that night.
Yes, I am.
correct? And so, and then you see Nadia on your way to that location, correct? And
Correct.
so it's more important for you to stop and tell Nadia to leave you alone than to go pick up your mother.
When I stopped there, I knew for a fact that there was cameras. I also knew for a fact that I was gonna record the entire conversation. And I also knew the fact that she had stabbed me before. But I'm not gonna sit here and be stalked and be ignored by police or anything. You're saying, what you're basically saying is she had the right to stop me, to say this, to do this. I'm not putting the blame, but I'm just saying that is what you're saying.
All right, well, let's talk about when you stopped there to speak with her, correct? Okay. You told the detective Martinez that you have your gun, you weren't concealed carrying, you were open carrying, correct?
Constitutionally.
Okay, and that they were aware that you had a firearm when you pulled up on her, correct? That's what you said?
No, like she can heard, and from her own testimony, she claimed that I always had something like that on me. So if that was already in her mind originally, why would she come at me with a knife? Why would anyone come near me if they were thinking I was already armed like that?
Okay. So she
like the-
stated in her testimony that she's aware that you're going to carry knives and firearms, you're calling on, correct? But I'm talking about your statement to Detective Martinez. You stated that you were open carrying and that both Nadia and Travis knew that you were in possession of a firearm that night. Correct. That's what you stated.
Their assumptions are what they made it. Now, what I stated was, yes, I was constitutionally carrying.
Go ahead
What
and-
I stated
Go ahead
and what they believe are two completely different things.
All right, so in that video clip of you speaking with Detective Martinez, you stated you weren't concealed carrying, it was open carry, so they already knew. That's what you stated, right?
The only reason I had that.
Okay, did you state that to Detective Martinez, yes or no?
That they had prior knowledge of that? But they
Did,
believe that.
listen to the statement. I was not concealed carrying, it was open carrying, so they already knew. Is that what you stated?
Yes.
Okay. Now, moving on. your testimony that you had all of these prior incidents or whatever, and that Nadia cut you, right? And she even admitted to that she had previously cut you prior to the offense. You heard that, right?
She admitted to stabbing me twice on the same offense. That's what I heard from her. I didn't hear anything about me
She
stabbing.
testified when you're.
And then we crossed the time, then she said about cutting me in half.
Okay.
This other incident, but she stated that she had cut me in half. It's a question right now.
All right. So he admitted to cutting you one time prior than the incident that we are here for today. Isn't that correct?
Correct.
Okay. Now, my question to you is if that she has already cut you before, why did you feel the need to stop her when she was minding her business, walking down Vance Jackson?
Because even though that was already time that she had cut me, that was not the only time she had come up to me even after the fact that she had cut me.
Okay, and so isn't it true that you stopped there because you wanted to antagonize her?
Incorrect.
Okay, so if you're in fear of her because she's cut you previously, why did you feel the need to stop?
If anyone's ever been faced with a situation in their life where they feel like no one's listening and no one cared, like you even said something else, you say a little 5 and 6, whatever you said about some great giant or whatever. No, like, was there a lot of red flags that went on? Sure, but my only intention was what it was to tell her to leave me alone. And I would say it in the video. You can say she was doing whatever, why you did this. But I was not following her. I wasn't stopping her from anywhere. I was stopping her from leaving. She ran off on her own volition. She chose, like it was stated, like, on her own volition to record my vehicle. She had previously vandalized my vehicle before, but she even stated too in the beginning of the video, actually, when she asked me why I'm in that, why are you in that car? Why was your other car? Did she not?
And so so your testimony is that you felt the need to be late. No, listen. You felt the need to be late picking up your mom, to stop her while she's walking down Vance Jackson because she had cut you before, and the only thing that you wanted to do was tell her to leave you alone. That's what you're telling this jury.
It's simply yes or no term, correct.
Okay. We pass the witness, Your Honor.
I have no further question.
All right, you may step down.
Thank you.
You're welcome. All right, defense, call your next witness. State, do you close?
Close.
All right, ladies and gentlemen, I'm going to read to you the charge of the court. Members of the jury, by your verdict returned in this case, you have found the defendant Johnny Delarosa guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment. It is necessary that the jury assess the punishment for this offense. You are instructed that the punishment for aggravated assault with a deadly weapon is confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 20 years or less than 2 years. Therefore, you will assess the punishment of the defendant for any term of not more than 20 years or less than 2 years. In addition to imprisonment, an individual found guilty of the offense of aggravated assault with a deadly weapon may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If you assess a fine, it is not paid to the victim, if any, but is paid into the registry of the court. The defendant has filed an application in writing under oath stating that he has never before been convicted of a felony and has requested that the imposition of any sentence imposed be suspended and that he be placed on community supervision. Community supervision means the placement of a defendant by a court under a continuum of programs and sanctions, which conditions imposed by the court for a specified period during which a sentence of imprisonment or confinement, imprisonment and fine, or confinement and fine is probated and the imposition of sentence is suspended in whole or in part. Our statute provides that where a defendant is found guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment in this case, and the jury assesses the punishment at not more than 10 years, and they further find that the defendant has never been convicted of a felony in this or any other state, the jury may, within its discretion, recommend community supervision. Whether you do or do not recommend community supervision for the defendant is a matter that rests within the sound discretion of the jury. If the jury does recommend community supervision, it will be granted by the court. If you recommend that the defendant be placed upon community supervision, the court shall determine all the conditions of community supervision and may at any time during the period of community supervision alter or modify the conditions. The court may impose any reasonable condition. You may not recommend that part of the period of confinement be served by incarceration and part by community supervision. Should the punishment assessed by you include a fine, a recommendation of community supervision should state whether or not the fine will be paid or be suspended and probated. If there is any evidence before you that the defendant may have committed an act of misconduct other than that for which you have convicted him, you are instructed that this evidence, if any, was admitted to assist you, if it does, in determining what sentence is appropriate in the case at hand. You may consider that evidence in assessing punishment only if you first believe beyond a reasonable doubt that the defendant committed such other act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such act of misconduct was committed, or as to whether the defendant was involved in such other act of misconduct, if any, then you will wholly disregard the evidence, if any, which may relate to any such matter. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. A suitable form is attached hereto for your verdict if you should care to use the same. However, such form is not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187 Judicial District Court, Bexar County, Texas. A verdict form is attached. State, are you ready to proceed?
Yes, Judge. Ladies and gentlemen, aggravated assault with a deadly weapon is a second-degree felony. That means the range of punishment is anywhere from 2 to 20 years in prison, or you can grant probation. You also have to make a decision whether to assess a fine. That fine cannot exceed $10,000. Here in a moment after the defense speaks, Ms. Galloway is going to get up here and expand on why this is not a probation.
All right, defense, you may proceed.
Ladies and gentlemen, I'm gonna leave it up to you. I think you recognize that we should be those. Yeah. I was concerned about. Clearly, there's no prior felony conviction. That's why we want to use punishment. It's eligible for probation. whether you feel it's appropriate is up to you. I do want you to consider, when you look at the jury charge, it talks about parole, these types of history. So a sentence of 10 years would be minimum 5 years, 20 would be, and it's up to you to decide what you feel is appropriate. I would ask you to consider granting application for probation to be assessed a sentence of 10 years. The court has the ability to assess a condition, perhaps. But you've been attended to this situation, I can help you through the thought process. I just ask you to take into consideration this week. If you consider giving an opportunity on probation, or if not, a lesser sentence of incarceration, taking into consideration not getting by.
All right, state.
Ladies and gentlemen of the jury, you heard the range of punishment anywhere from supervision, also known as probation, and conditional release into our community. Okay, anywhere from that, or anywhere from 2 to 20 years in prison. Okay, I am asking to deny the defendant application for community supervision. And I am going to talk to you about the reasons why I am not. If you look at the chart, which is the law that governs you, that was given to you by the court, it says that should you grant community supervision, that the court may impose conditions for a specified period of time. But pretrial release is kind of like a crystal ball into what we can expect from a defendant. If a defendant cannot comply with his terms of pretrial release, it's almost guaranteed that he's not going to be able to comply with any conditions that were set for him on community supervision. Now, you heard testimony that while he was on bond, that he was on an ankle monitor, okay? And while he was on that ankle monitor, those are rules that are given by the court for the protection of our community, okay? You are not supposed to go in unauthorized areas. That is for a reason. That is something that a defendant needs to heed to. And even though defense wants to say, oh, it was just Whataburger at McDonald's and Walmart or HEB Plus, wherever it was, this is a crystal ball letting us know that the defendant cannot comply with rules that are imposed by the court. Now, when we talk about, it says the jury can assess the punishment of not more than 10 years. Okay, so if you wanted to grant his application for community supervision, you would have to assess a 10-year prison sentence or less. However, I've already stated I am asking you to deny his application for community supervision. So should you think, hey, I believe that this case is only appropriate for 8 years in prison, you are able to assess the 8 years still denied application for community supervision. Okay. That is within the sound discretion of you all as attorneys, considering all of the evidence that you've seen throughout the duration of this trial. The video evidence that you saw in real innocence, and also the state's exhibits that we brought you and punishment as well. Now, you heard testimony from Officer Lesh, okay, that he responded to the scene of that circle pin. That he took the report from Nadia, and then you heard from Nadia, all right? And she testifies about this timeline, and I want to make sure I get it correctly. But she testifies that this was not the first time that the defendant has aggressively pulled over on her and started harassing her. And this cannot be considered anything other than harassment. It's the repeated, continual pursuit of Nadia Newton at what cost and for what? According to Mr. Delarosa, it's just so that he can tell her that she needs to leave him alone. But we need to look at what the evidence supports, and that's that Nadia is not the one pursuing him, okay? It is him pursuing her relentlessly. And And so let's talk about this timeline that she testified to. She made that prior report about him aggressively pulling up on her at Whataburger, and that was on July 8th of 2020. Okay, and then some time passed, and then she makes this other report on February 15th of 2024. And that is when he popped up at her place that she works at the Circle K where she is employed, bothering her. And for what? Mr. Mallard asked the question to her, why did she need to allegedly go to his place of employment? But if these things are escalating and it's getting closer to his office date, why, if he was working at 7-Eleven, why did he need to go to her place of employment? And the specific instances and bad acts of the defendant that the state has brought you, they are substantiated and corroborated by video evidence. Okay, we're not saying, oh, there's some witness out wherever that is not coming into court to testify. We've brought you this stuff in the form of exhibits. Okay, and then ultimately we get to the offense date, April 9th of 2024. Ladies and gentlemen, you heard Mr. Delarosa's explanation for why he did what he did. I do believe him that Ms. Delarosa did the best job that she did raising him. And, you know, bless her heart, it's no fault of her own, but he is a danger to our community. He fixates on people and he does not stop until he ends up in a court of law, having to answer to a jury of his peers. That is the most dangerous type of individual to be wandering out there. And you need to think about what type of community you want to live in. Do you want to live in a community where this defendant gets to constitutionally carry his firearm and aggressively pull up on people that are minding their business and then come into a court of law and say, "Doc, I was acting in self-defense. I was just telling her to leave me alone," when there's no evidence that she was ever bothered. Those are things that you need to consider when you retire to jury. He stated that his life is on the line, but he placed Nadia's life on the line that night, and that is something that he came for. He stated that this was a mistake, and it was not a mistake. It was a conscious choice that he made over and over and over again. So I am asking you to assess a punishment of anywhere between 8 to 12 years in prison, along with the $2,000 fine.
All right, ladies and gentlemen, you're retired back to the jury room, and as previously stated, the alternate, if you'll wait in a separate area. All right, everyone, please rise for the jurors. My allergies have been killing me. to receive the verdict? All right, so everyone, there's to be no outbursts. And Mr. Maurer, did you review with your client the trial court certification? All right, thank you. All right, let's bring the jurors in. All right, everyone, please be seated. Ladies and gentlemen, it's the understanding of the court that you've reached a verdict on punishment. Is that correct? And is that verdict unanimous? All right, if you'll hand the verdict form to Deputy Laura, please. Thank you. All right, if the defendant will please rise. The punishment verdict reads as follows. We assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 7 years. There's a $1,000 fine, and it states that the defendant's application for community supervision be denied. You may be seated. Does anyone wish to have the jury polled? All right, ladies and gentlemen, thank you so much for your service. I'll come and speak with you briefly. All right, everyone, please rise for the jurors. All right, everyone, please be seated. All right, Mr. Delarosa, having been found guilty by the jury, the court will impose the sentence that has been requested by the jurors, and your sentence will be assessed at the following: 7 years in the prison. There's an affirmative finding of deadly weapon. There's a $1,000 fine. Time and money will run concurrently. And counsel, I'll request the therapeutic community just to address any issues that your client may have or he feels that he may have. Is there anything else with regards to sentencing? Would you like a no contact order? There's to be no contact with Nadia Newton or any relatives or friends of Nadia Newton. Is there anything else from either side with regards to sentencing? All right, Mr. Delarosa, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Could you get back to one? All right, you do have a right to appeal as this was a jury trial. Do you understand? All right, what will end up happening is either this attorney or another attorney, if you decide to appeal, will be appointed to represent you at the appellate level. Do you understand? All right, do you have any questions about anything, Mr. Delarosa? All right, is there any victim impact? All right, thank you.
Yes, I'm retained. I'm gonna give Congress to the bar.
All right, if you're, just 1 second for Mr. Delarosa. So counsel, if you're following the motion to withdraw, will he be able to hire an appellate attorney if he decides to?
I guess. This part of his mom.
All right, so then what we'll do is just file the motion if he decides to appeal, and then we'll set it for a hearing and we'll have a hearing on indigency. All right, thank you. You're welcome.